I'm going to go ahead and turn it over to
Test.
Dr. Johnson, the chairman of the Medical Cannabis Advisory Board.
Good morning, and thank you for coming as well. Can you hear or not? Okay. Good morning. Thank you for coming. Good morning. Thank you for coming. Okay, that's better. Okay. Good morning. I'm Dr. Bill Johnson, the current chairman of the Medical Advisory Board of the Medical Cannabis Program. I am also the psychiatric member of the committee. There are certain introductory remarks that are required, and I will go forward with those. This hearing of the New Mexico Department of Health Medical Cannabis Advisory Board will now come to order. I would like to welcome you to this public hearing for discussion of the current status of the program and to review the rest of the agenda, as hopefully you were able to get copies of the agenda. Pursuant to notice, this matter is being heard this first day of May 2015 in the auditorium of the Harold Reynolds Building, 1190 St. Francis Drive, Santa Fe, New Mexico. The time is approximately 10:13. I'm Dr. Bill Johnson, the current chair, and will be managing the first part of the hearing today until we have the election of a new chairperson. Mr. Woodward, the DOH Assistant General Counsel, will be advising the department in the proceeding. This proceeding is being held in accordance with the Lynn and Aaron Compassionate Use Act, sections 26-2B-1 through 26-2B-7, and the regulations of the NMAC Title 7, Chapter 34, Part 2. If members of the audience have not already done so, please sign the attendance sheet located at the entrance of the auditorium. We will proceed with the hearing by going through the agenda. There are no new petitions from members of the public today, so we will move forward with the agenda. Right, thank you. Let's see. Anything else? And this board will accept comments from members of the public later in the meeting after the discussion of the agenda amongst the members of the advisory board. When we get to the public comment stage, we ask that people limit their comments to 2 or 3 minutes so that we have time for everyone to offer their comments. Okay, I think I've done that. All right. So I would like to welcome new members to our Medical Advisory Board. We're filling out the ranks, and I would also like to note the passing of another member of another former member of the Medical Advisory Board, Dr. Eve Elting, who passed away from cancer late in 2014. We're sad to acknowledge that, but welcome Dr. Baylin Schwartz on my right, who will say a few words about her interests and qualifications.
Hello, so I'm Baylin Schwartz. I'm a physiatrist, physical medicine and rehabilitation physician. As such, I have been practicing here in Santa Fe for 20 years. I'm currently employed by Christus St. Vincent Hospital, and I do rehabilitation medicine in an outpatient setting. I see patients with a variety of issues, rehabilitative issues, including spinal cord injuries, head injuries, strokes, other injuries that result in pain and chronic pain. I have a subspecialty in pain management, and I was asked to be a part of this board recently, and I was honored to be asked. I see in the pain management world, we have very limited management tools, and many of them have a lot of side effects. And so in agreeing to be on this board, I was happy to, or I felt that it might help me understand the role of medical cannabis in pain management a little more. So thank you.
Thank you, Dr. Schwartz. To my immediate right is Dr. Laura Brown, who is the family practice representative. She's a several-year member of the committee. To my immediate left is Dr. Stephen Jennison, the original medical director of the medical cannabis program and a reappointed member of the medical cannabis medical advisory board. Then there's Dr. Tim Lopez, who serves as the representative for oncology. And at my far left is Dr. Jeffrey Nelson, a new member, and I'm going to let him introduce himself and his interests.
Hi, thank you, Bill. Jeffrey Nelson. I'm a neurologist in the flat brown part of the state of New Mexico. Well, it's southeast. He said which part of the flat brown part of the state. So I am a board-certified neurologist. I have subspecialty certifications in headache medicine, and to my knowledge, I'm the only one in the state of New Mexico with that certification, and also sleep medicine. And as many of the doctors here know, there's many conditions that I treat that have no or limited FDA-approved treatments. And so we're always looking for other opportunities to help our patients, which is why I'm interested.
Thank you, Dr. Nelson. After having served for 2 years as the chairperson of the Medical Advisory Board, I would like to resign that position, and the next item of business would be to elect a new chairperson from amongst the members. And I would like to nominate Dr. Stephen Jennison. Would anyone else like to put their name in for consideration as chairperson?
I'd like to second that motion, that Dr. Jennison become the new chairman.
That sounds good to me. Any other, Tim, are you interested in? All right. Well, let's, any discussion about Dr. Jennifer's qualifications? I think as everyone in the audience and up here on the podium already knows, he is well qualified to serve in that position, having been one of the initial, as I said, the initial medical director of the whole program. So without further discussion, let's take a vote. All those in favor on the podium, please say aye or raise their hand.
Aye.
It appears to be unanimous. So I will turn the meeting over to Dr. Jennison.
Thank you. I'm honored to be the chairperson, by the way, and I accept. The next thing on the agenda, generally the medical cannabis program gives us a report of where things stand with regard to enrollment, and also there have been recent rules changes that were published on, I think, February 27th or something like that. So this is an opportunity for the program to update us on what's been going on since the last Medical Advisory Board public hearing. Ken Groggle, program manager.
Thank you, Dr. Jennison, and welcome back.
Thank you.
So there's been a lot going on, as you're all aware of, in the last, since we last met, I should say, as a Medical Cannabis Advisory Board. So let me give you some updates here. First and foremost, statistics as of 4/30 of 2015, active patient enrollment, 14,099. Significant numbers in that area. Approximately 45% of total enrollment is under post-traumatic stress disorder. Chronic pain comes in at approximately 26%, and various forms of cancer are approximately 9%. Those are the three most significant conditions for enrollment at this time. Another point of interest, there are currently 3,625 personal production licenses active within that enrollment. As you're all aware, there's been some changes in the rules that went into effect as of February 27 of 2015. I'd like to now highlight a few of those that are also can be found in other postings. 734.48, licensing general provisions. Licensed nonprofit producers can now grow up to 450 total cannabis plants. They can make steps from 150 by increasing by 50 plants at a time with a commensurate fee to make that production increase. The chronic pain qualifying conditions have eliminated, one medical signature. So for new enrollment, medical certification must be completed by a pain management specialist or a specialist with expertise in the disease process that is causing the pain. On renewal, applications for medical certification may be signed by a primary care provider. The quantity of usable cannabis that may be possessed by a qualified patient or primary caregiver in any 3-month period has been increased to 230 units, is equal to 230 grams of flowered cannabis. This is an increase of approximately 60 grams from the current or the previous standard. Important to note is 1 unit of usable cannabis equals 1 gram of dried leaves or flowers, or 0.2 grams, 200 milligrams of THC for a cannabis-derived product or edible. In addition, applicants who are interested in going beyond that limit may apply for an additional 115 units of an increase in THC over 70% with an accompanying medical provider determination notification to the program. The department is now approving manufacturers of cannabis-derived products. This means edibles, topicals, tinctures, waxes, all forms of, for lack of a better term, non-flower product. They also have, we now have introduced rules for department-approved testing laboratories to bring those folks into the cadre, for lack of a better term, to ensure that patients receive safe, tested medicine. Also, couriers have been brought into the rules at this time. This creates a process for the department-approved couriers to deliver medical cannabis to qualified patients. Another interesting change of note, producer testing of usable cannabis requires them to test now for microbiological contaminants, mycotoxins, solvent residues, as well as the potency in relation to the quantity of THC and CBD before distribution. In this area, it's important to note that the standards for heavy metals have been withdrawn from the rule at this time, and they will be under review until determination is made. So that is not at present a requirement in the testing regimen. Qualified patient primary caregiver registry ID cards. We have the opportunity now with potential upgrade in the software systems that the medical cannabis program is using to be able to include a photograph of the qualified patient or primary caregiver on the card. So that's a potential coming in the future. Qualified patient, primary caregiver, registry ID card application. It's important for you to be aware and take care of your cards because replacement now comes with a $50 fee. A qualified patient or primary caregiver shall now ensure that all cannabis and cannabis-derived products are kept secure and out of the reach of children. Possession of usable cannabis, a qualified patient and primary caregiver shall ensure all cannabis and cannabis-derived products remain in the package or container provided, or retain all packaging if transferring to another package or container. So keep your receipts, keep the labels if you opened it and you still have product left. Let's see. Another important point, possession of usable cannabis for qualified patients or primary caregivers. You may transfer cannabis or cannabis-derived products of your own making or others to an approved laboratory for testing. So patients now have access to testing services. Qualified personal production application and licensure requirements. There are now standards that say that only 2 personal production licenses may be issued for a given location, as long as there are 2 registered patients at that location. Qualified personal production application licensure. If you intend to grow cannabis at a location that is not owned by the applicant, you must submit a written statement from the property owner or landlord that grants them permission to grow medical cannabis at that location. These are some of the significant changes that have occurred. There's many more. This isn't comprehensive, but some that we've identified for you. Another thing to take note of, and probably most of you are aware of this, the department has opened the application process for adding new licensed nonprofit producers. The closing date is today by 4:30 this afternoon for applicants. At this time, we've received in the neighborhood of 20 plus, just for your information. Really, I think that's some of the biggest highlights that I would like to notify the people in attendance here, so I'll turn it back over to the advisory board. Thank you.
Thank you, Mr. Groggle. You know, these hearings, part of these hearings is the hearing of petitions for the addition of new conditions to the list of those that are eligible for enrollment in the medical cannabis program. But we received no petitions from the public this time around. One of the other responsibilities of the Medical Advisory Board under the statute, under the Lynn and Aaron Compassionate Use Act, is to make recommendations to the Secretary of Health about changes in rules that apply either to the patient registry or to the Medical Advisory Board itself. That having been said, I actually proposed the hearing of a few potential rules changes today, and then Dr. Johnson sort of internally asked that we clarify the qualifying condition of hospice care to expand it to include palliative care. So we'll have a discussion of that. Those of you who don't know the difference between hospice care and palliative care, don't worry. We'll talk about that when we get to hearing that petition from Dr. Johnson. So the first thing that I'm going to do then is to discuss the things that I proposed, which are potential rules changes for the patient registry. Relevant to that, in the Santa Fe New Mexican today, I saw a story that said that a local judge had made a ruling that the current requirement that a patient and their certifying clinician attest to the fact that standard treatments have been tried and failed has been struck down by that judge in a case that was brought by Dr. Carla Kiva, sorry. So a couple of the things that we're going to be talking about today are germane to that, and I was wondering if Mr. Woodward would be in a position to tell us the status of that suit and what the department's intentions are with regard to the ruling of the court.
Thank you. Can you hear me?
Yeah.
So the department just received that order very recently, and the department is still in the process of evaluating what the potential effects are. I think that the description that you've given of the order is pretty accurate, and the description given in that article was pretty accurate. So at this point, the agency is just weighing its options as far as potential for appeal or for other actions. And since it is pending litigation, we're not in a position where we can really discuss the substance of that case or the likely outcome of it, especially at this point, since we don't know exactly what is going to happen. But your description of it is correct.
Well, yeah, and the one thing that I guess I wanted clear, I understand that you potentially have a conflict of interest representing the Department of Health and representing the Medical Advisory Board in this case.
I don't see how.
Okay, in that case then, could you please tell us whether it is just the issue of having exhausted conventional treatments, or are there other aspects of rules that have to do with how the department reviews an application that were part of that case as well?
Well, I can tell you generally that the thrust of it was the attestation that standard treatments have failed to bring adequate relief, but there was another piece to it, was the application criteria specific to PTSD, since Dr. Kiva was suing related to the criteria for that.
So could you flesh that out a little bit more?
Unfortunately, I can't. And now I understand that you consider this to be a conflict of interest, and
by any other name?
Of course. Well, I don't think it's anything close to a conflict of interest. And I've heard this argument before, but I'd like to be clear that my relationship to the advisory board is no more a conflict of interest than the advisory board's relationship to the Department of Health. The reality is that the advisory board is advisory to, and within the Department of Health under statute. If there's a perceived conflict, then it's a statutorily created one, and you should talk to your legislator about that.
Okay. So, given that the newspaper article really said nothing about what the issue was with regard to the certification under PTSD, could you just give us a clue about that so that we sort of know about?
And I don't want to misstate, because it was a complicated case, but the thrust of it with respect to the PTSD application had to do with medical documentation and the submission of medical documentation, and the contours of it from the order. It's a complicated order. To some extent, the court held that the Department of Health does have the authority to require the submission of medical records in support of either an initial or renewal application. But to another extent, the court was saying in its order, Judge Thompson was saying in his order, that what the department can use that for is limited, in his view, under the statute, and that it's limited to verifying the truthfulness of the application.
Right, okay. Thank you. Right, so the recommendation that I have proposed for the Medical Advisory Board's review and forwarding to the Secretary of Health for her action is directly relevant to that. I have, there is currently in the patient registry regulation 7.34.3, the requirement that the certifying clinician attest to the fact that standard treatments have been tried and failed. That is also apparently the subject of this court ruling. The argument that I am making is that, and probably quite likely the argument that the court made as well, is that the underlying statute, the Linen Aaron Compassionate Use Act, which took about 7 years to pass altogether. Those of you who were around for that, it took from the year 2000 until the year 2007 for a medical cannabis law to finally be passed in New Mexico. During that period of time, there were every possible detail that you can imagine in terms of what should and should not be in that bill was considered in one committee or another or on the floor of the legislature. And ultimately, the decision of the New Mexico legislature in the Linen Aaron Compassionate Use Act was to require basically only two things from patients making application for enrollment in the program. One was to have a condition that was defined in the law or that was subsequently added by the Secretary of Health upon the recommendation of the Medical Advisory Board. The second was an attestation by a certified, by a prescribing clinician in the state of New Mexico that the person had that condition. And the Linen Aaron Compassionate Use Act specifically states that if those two things are present, and if they are truthful, that the department is not in a position to turn down the application. The regulation that required the clinician to attest to the fact that standard treatments have been tried and failed was added by the Department of Health through the rulemaking process. And it's my understanding from reading an article in the Santa Fe New Mexican, which is usually pretty authoritative, is that the judge ruled that the department had overstepped its authority, its rulemaking authority, by adding that to the regulation. Is my interpretation of that fairly correct?
I think that's generally correct.
Okay, thank you. So, with that in mind, I think there are also, besides the legal issues, I think there are also medical issues about that. There are people, I mean, I'm a practitioner of Western medicine, but I think that I have a healthy respect for what Western medicine can and cannot do. And I think I also have a respect for the principle of patient autonomy, which is that people really ought to be able to make decisions about their own health and their own health care. That we as clinicians are in a position where we are meant to uphold a principle called beneficence, where we have the interest of the patient at heart, and we can counsel a patient, and we can treat a patient, and we can give them advice, and we can tell them what we think they should and should not do, but ultimately it's their decision to make that beneficence only goes so far before it actually becomes oppressive and treads on the principle of patient autonomy. So it is my strong feeling, and has always been my strong feeling, that people who find that they have used medical cannabis for certain things for which they find significant relief should not necessarily need to subject themselves to some Western medical treatments, some of which have a very shaky foundation in terms of their proven efficacy. So I am proposing, and I open up for discussion by the other members of the board, a recommendation to the Secretary to remove the requirement in the rule 7.34.3, the patient registry, the requirement for a clinician to attest to the fact that standard treatments have been tried and failed.
May I just clarify, does that pertain only to the diagnosis of PTSD or all the diagnoses?
Sorry to interrupt. Can you hear me? In the rule, it applies only to department-approved conditions, so it refers to all of the conditions that were approved by the department, but not statutorily.
And can you explain what the rationale for that would be?
The rationale as far as the distinction and not making it applicable to statutorily approved conditions?
Yes.
I think it was the feeling of the agency at the time that was added in 2010 that it would not be able to alter the requirements specific to the statutorily approved conditions, but that it had more leeway with respect to the department-approved conditions.
Okay.
So that means that the 7 original conditions are not subject to that requirement, but the additional ones, including PTSD, severe chronic pain, and the other, aren't there 19 total conditions now or something, have been having to go through that little filter. Is that right?
That attestation requirement.
I'm not sure what is to be gained. It sounds like we've already had a court ruling on this, and it's based on my review of the New Mexican article. So, well, the reason I've just brought this up is sort of a moot point. I think we just read in the New Mexican this morning that there's been a court ruling on this very topic, and so.
Well, I would say that as Mr. Woodward said, the department has not yet decided what its response to that ruling will be. So it is entirely possible that the department could appeal the ruling. Therefore, I think, and I brought this up as a topic of discussion before I knew that the ruling was going to appear the day before we had our public hearing. So I think we are still in a position to be able to make a recommendation about a rule change for a rule that still exists.
So is this something you need a motion for and a second and a vote? Is that what
Yeah.
you're requesting?
Yeah, after discussion,
Okay.
whoever wants to.
Usually you make the motion, then
Oh,
you
okay.
discuss.
All right.
So I'll move that we go ahead and do this.
I guess I need some more clarification about what was just mentioned, why the original 7 conditions would not fall under this new ruling.
They've been exempted, it appears to me. That filter of standard treatments have failed to provide adequate relief, which is the phraseology on the application, has been only applied to the 12 conditions approved by the department since 2009 when the public hearing process began.
So then the original 7 conditions, there would be no possibility of having additional medical documentation provided. That wouldn't be added to that, or those original 7 would not be at risk of having people be required to provide evidence that standard medical treatments had failed.
That's my understanding.
So, okay, so no additional medical evidence needs to be provided for those original 7 that standard medical treatments have failed. Okay, great. I just needed that clarification. I also wanted to say before Dr. Johnson handed over the chairmanship over to Dr. Jennison, I wanted to thank Dr. Johnson for his incredible leadership over the last 2 years of this medical advisory board.
So Chris, let me ask you one other question, which is in the ruling, did the court case just involve PTSD and did the ruling that the court found that the requirement for the attestation to conventional treatments having failed, does that apply just to PTSD, or does it apply to the rule in general in particular?
In
To the-
in
to the-
general,
to the
in
department-
particular?
To the department
Um,
added conditions.
That's a good question, and I would have to. We're reviewing and re-reviewing the order to get a sense of the contours of it, but I think generally the order was specific to PTSD, but since that particular requirement is something that it's not particular to PTSD, it's department-approved conditions, I suppose it would be broader in its scope.
Okay. Any other discussion?
I'd like to add to what Steve already had talked about in terms of the discussion of patient autonomy, that in addition to the shaky foundation of efficacy for many standard medical treatments, Western pharmacology, so to speak, there are significant side effects that we're all aware of, including both morbidity and mortality. I'm thinking particularly of opioids and the risk of overdose death, and just a reminder that there is no lethal toxic dose of cannabis that I'm aware of in the literature, and so I think this needs to be added to the discussion in support of patient autonomy as it applies to these medical qualifying conditions.
And I'll mention this again later in the discussion about certification for severe chronic pain, but there was a paper that appeared, a journal article that appeared recently where they analyzed the opioid overdose death rate, comparing states that had medical cannabis programs and states that did not have medical cannabis programs, and found that in those states that have implemented medical cannabis programs in the past several years, that opioid overdose death rates have gone down, whereas in every other state in the United States that doesn't have a medical cannabis program, opioid overdose deaths have gone up. There's methodological arguments about that paper, but it's an interesting finding that certainly deserves more study.
Right. This adds to, I think, the important body of existing medical literature about the opioid-sparing effects of use of medical cannabis, which is super important, especially in the context of the risk of overdose and overdose death from use of opioids, something that many of us, unfortunately, come into contact with here in New Mexico. I actually pointed this article out to the secretary yesterday in my reappointment interview, and she was glad to take note of that.
And it appeared in a major journal, JAMA Internal Medicine, so it's been peer-reviewed up and down.
Dr. Jennison? I'm sitting here arguing with myself internally, and I just want some comments from you and maybe the others. Although I would like to be able to do whatever I want to be done for a patient, there are also many patients who want things that they shouldn't get, and that's going to make the doctor-patient relationship a little more difficult if there is no restriction on these patients at least trying some standard therapies. And I know that's not another doctor's problem, but it is something to consider. Any comments on that?
Yeah, it sort of gets to a commonly and constantly debated question of what the role of a clinician is in the context of the Linen Air and Compassionate Use Act and the medical cannabis program. It's pretty clear from the discussions that I heard. I went to basically every committee hearing during the period of time that the bill was being heard, and the floor discussions, as well as being involved in the discussions with the original implementation of the program. It is pretty clear that the intent of the legislature was that the role of the clinician in the certification process was simply to certify that the person had the condition under which they were seeking enrollment in the program. There was basically nothing more in the statute, stated or implied, that suggested the establishment of an ongoing therapeutic relationship between the physician and the patient subsequent to that. It is in part that limited role of a clinician in a medical cannabis program that protects a clinician under the ruling Conant versus Walters, which says that a clinician has a First Amendment right to advise a patient about enrollment in a medical cannabis program, but Conant pretty clearly says that if it goes much beyond that, if you're actually prescribing people cannabis or stating what kind of cannabis they should have, that things become shakier, because under federal law, cannabis is still a Schedule I drug. So it really depends upon what you view the role of a clinician in regard to the program is. My view is that the clinician, and this has also been a discussion with the New Mexico Medical Board, and my position is that the law is pretty clear that the role of the clinician is to verify that the person has the condition under which they're seeking enrollment in the program. What you would seek to do with a patient beyond that, I think, is kind of your prerogative, and is it's dependent upon what your relationship with that patient is. But whether the clinician is in a position to, you can always not certify somebody, right? So if you decide you don't want your patient for whatever reason to be enrolled in the program, then it is your prerogative as a clinician to not provide certification for them. And I think that's what you could do. But I think that if somebody is seeking certification, the law is pretty clear about the role of a clinician.
Thanks for those comments. I am trying to honor the law, and also please understand that I don't necessarily give a damn about the law either. I'm trying to do what's best for my patients and the best for my practice.
Sure.
So you can understand how patients ask for a lot of things that they don't need and they don't understand adequately. So you can understand if there was no necessity for failing any kind of conventional therapy, how we would simply turn into marijuana doctors. And that's each doctor's choice, and they have to live with that, I understand that. But it does complicate the relationship some.
I agree. Any other discussion? I can't remember if I had a second to that motion. The motion that Tim made the motion.
So, Steve, on our agenda, we have 5 items here.
This
We
is
have-
number 3, I think. The removal of the
So,
requirement.
Are we going to need individual motions for each of these 5 items?
Yes.
We are?
Right, so, yes.
So, the motion is that removal of the requirement that standard treatments have failed to bring adequate relief unless practitioner determines that standard treatments would be harmful to the patient's health. I move that we remove that requirement as it currently exists.
I'd like to second that.
All in favor of the motion, which is the removal of the requirement that standard treatments have failed to bring adequate relief unless the practitioner determines that standard treatments would be harmful to the patient's health, which is 7.34.3.8C3 NMAC, please indicate by raising your hand. All opposed? Okay. Thank you. The second motion is kind of related, which is, well, kind of and kind of not, I guess. The second one is the, which is actually number 1 under agenda item 6, the removal of the requirement in the case of enrollment for severe chronic pain for certification by a specialist with expertise in pain management or a specialist with expertise in the disease process that is causing the pain, which is 7.34.3.8B1 little b. I don't know how you say that in legalese. Lowercase. Thank you. A little bit about the history of this. So severe chronic pain, the history as I remember it. Severe chronic pain was added as a condition by the Secretary of Health, who was Alfredo Vigil at the time, upon the recommendation of the Medical Advisory Board. Dr. Vigil agreed to the addition of severe chronic pain, but insisted that the diagnosis be confirmed by a person with specialty expertise in pain or pain management. That requirement has undergone some modifications over the years, some of which I've been able to track and some of which I haven't. At one point, it became a requirement. So as I remember it originally, there was the requirement for the pain specialist on the initial certification, but not a requirement for the specialist certification in subsequent recertifications. But then at some point, the requirement for the pain specialist certification got added to the yearly, and then it got taken away again in the most recent iteration. It's true that it got taken away in the most recent iteration, correct? Yeah, okay. So the question, I guess, is whether or not the requirement for a certification by a pain specialist is a, number 1, legal, number 2, reasonable, and number 3, practical. So I think the legal argument is that there is nothing in the statute that indicates any requirement at any point for hang on, bear with me just a second. Yeah, I'd also like to expand this discussion to include rheumatoid arthritis. There's also a requirement in the regulations that says that a person applying under the condition of rheumatoid arthritis needs a certification or needs documents from a rheumatologist, and not only a rheumatologist, but indeed a board-certified rheumatologist in the state of New Mexico in order to be certified under the condition of rheumatoid arthritis. There aren't a lot of rheumatologists in the state of New Mexico. And they're kind of few and far between, and they're curiously distributed geographically.
May I add that there are not a lot of pain medicine specialists either, and I don't always know what constitutes a pain medicine specialist, but I know in Santa Fe there aren't many.
So I would start out with number 1. I don't think that it is consistent with the statute. The statute says that you need to be a prescribing clinician in the state of New Mexico. So you can be a physician, you can be a nurse practitioner, and in the case of PTSD, you can even be a prescribing psychologist. So I don't think that it's consistent with the statute, and sort of running along the same argument as the requirement that standard treatments have failed is kind of beyond the authority of the rulemaking authority of the department. I would argue that likewise the requirement for these specialists is beyond the rulemaking of the authority of the department too. And it just seems curious to me that a rheumatologist is required for rheumatoid arthritis, but a neurologist isn't required for multiple sclerosis, for example, or, you know, that a gastroenterologist is not required for Crohn's disease or ulcerative colitis. It seems a bit arbitrary that it should be these particular conditions that have been singled out for requiring the subspecialist. The other argument that I would make is that we're a small state and we're really dependent upon family medicine docs, general internal medicine docs in our community. You know, my clinician is a nurse practitioner in Embudo, New Mexico, you know, and I'm glad that I have access to him. So I think that requiring a pain specialist or a rheumatologist is an undue burden upon people seeking enrollment in the program. It wasn't intended under the statute, and that what it tends to do is impose both logistical and financial hardships on people who are seeking enrollment in the program.
So, Steve, I would add to this part of the discussion. I also think it's restrictive, overly restrictive of access along the same lines in terms of shortages and inadequate numbers of providers. In terms of PTSD, there aren't even enough psychiatrists, psychiatric nurse practitioners, or prescribing psychologists in the state of New Mexico, I think, to be able to provide appropriate access to PTSD certification for the medical cannabis program. And we have here, as the Medical Advisory Board, have pointed this out several times in the past and have made our recommendations about it, but I think it's germane to this part of the conversation to add to the fact that there aren't enough rheumatoid arthritis board-certified rheumatoid arthritis docs. And so I think that's part of it, and it's actually part of this also. It's number 2. Do you agree?
Yeah.
So
I actually heard a personal testimonial last evening by a friend who has someone close to him who has to go to Durango to see a rheumatologist, but because this person has to go to Durango to see a rheumatologist, and because it's not a New Mexico clinician, even though this person clearly has rheumatoid arthritis, because their rheumatologist is in Colorado, they can't certify under the condition of rheumatoid arthritis, which just seems kind of weird to me.
Just as further background, I have a copy of Secretary Ward's final decision from July 26, 2013, where she declined to remove the certain renewal enrollment criteria for PTSD and chronic pain. And in that document, she cited the current pain, at that time, the requirement for 2 other clinicians in the pain category, and that the overall argument was that this was not overly burdensome for either initial or renewal applicants from their analysis of the data that they had received, and that the enrollment requirements for patients in the program are already significantly less restrictive than the requirements for ordinary prescriptive medicine. She spoke to the fact that there would be a possible abuse of the two qualifying conditions or the perception of abuse, particularly in light of the Schedule I status of the substance cannabis. So she felt it was incumbent upon her to turn it down in order to keep New Mexico's program out of the federal spotlight.
Again, I refer to that paper that shows a decline in opiate overdose deaths in states that have implemented medical cannabis programs. I think when thinking about the treatment of severe chronic pain, we need to always keep in mind what the alternatives are to the use of cannabis, which is opiates, benzodiazepines, muscle relaxants, all of which are drugs that are pretty potent, have remarkable abuse potential, true addiction potential, and if there are population data that indicate a significant reduction in population level harm as a result of the use of cannabis for chronic pain, that rather than trying to put more barriers in the way, we ought to sort of be embracing that as a way of moving New Mexico away from the direction of being, now we're second in terms of opiate overdose. We're right behind West Virginia, but it's always neck and neck. So I think
it's also important to point out that I do believe the landscape of medical cannabis nationally has changed significantly since this was written in July of 2013, from the federal level to the state level to the local level. And so I think it's more of a political issue, quite frankly, than just a straight medical or clinical issue, but I think it is important to take that into account. I don't think there's as much fear of the feds swooping in to states with medical cannabis programs in May of 2015 as there was in July of 2013.
Just a reminder about that, when we were first implementing the medical cannabis program, and in fact when severe chronic pain was being added, it was under the George W. Bush administration, and the New Mexico Attorney General was getting communications from the U.S. Attorney General's office indicating that there was a distinct possibility that if we went ahead with the implementation of cannabis production in New Mexico, that we would be arrested. We, as members of the Department of Health, would be arrested and prosecuted. And we actually did drills to prepare for that possibility. I really don't think that there's any realistic concern about that anymore. And so, you know, if part of the concern about adding these other barriers to the enrollment of things that could be anticipated to be well enrolled, like severe chronic pain, if that was part of the rationale, I don't think that that exists anymore.
Dr. Johnson, I don't want to put you on the spot, but I just want to brush up on my knowledge of the psychiatric literature. Are you aware of any good studies showing that a individual or population of individuals with no psychiatric illness can have any detriment to their health or mental state with the use of chronic cannabis?
Very good question, Dr. Nelson. The primary concern is early onset and ongoing use. So if you initiate use during early adolescence prior to age 16, there appears to be a risk of IQ deficits measurable 25 years later with continued heavy use. The concerns about psychosis and the psychotogenic, as the possible psychotogenic properties, particularly of THC, have been investigated in ways that seem to promote the psychotogenic effects, i.e. by use of IV pure THC rather than a smoked product which typically contains both THC and more or less, depending on the strain, some of the other cannabinoids. And in people without any history or genetic vulnerability to severe mental illnesses, there does not appear to be any research suggesting increasing impairment with ongoing use. People in my practice, and I've done certifications for PTSD now for 5 years, so have 5 years worth of experience of them coming back for the annual recertification. They report less impairment over time, less use of benzodiazepines and SSRIs for their mood disorder problems. So I am cautiously optimistic that we do not have a problem in that respect.
Any further discussion? So what I'm going to propose is what I'm going to propose is that 6.1 actually speak to the removal of the requirement in the case of enrollment for severe chronic pain as well as for rheumatoid arthritis, because those both are.
I'll second that.
Okay.
Clarification, that would be any clinician licensed in the state of New Mexico
Yes.
would be able to certify.
Would be able to attest to the fact that the person has the diagnosis for the purposes of certification. Yeah. I guess.
Okay, we need
I think we're there, yeah. So all in favor of, so is the motion clear to everyone?
So this is for initial certification. It's not.
Right. Because the requirement for renewal has already been done. Okay, all in favor indicate by raising your hand. All opposed? Very good. So I'm going to note that Dr. Nelson is opposed.
And then Dr. Simpson was not able to attend today, but I got an email from him earlier. And let me He voted yes to remove the second specialist requirement in initial application.
I'll note that in the minutes.
So he, yeah, the proxy vote.
That's what I meant to imply. Okay.
Even if it says you can have my proxy on the following items, if you. Okay. But that's his.
Sorry, I have to do my. All right. On to PTSD. We generally try to take comment at the end. One of the things we're going to talk about a little bit later is the process by which you all get sufficient notification of our public hearings and what's going to be on the agenda so that you can indicate to the Department of Health 2 weeks before the hearing that you intend to speak specifically to things that are on the agenda. And we tried to do that this time around and actually didn't get any response. So,
Can we ask a question?
you can ask a question. We will discuss things at the end of the hearing. We just pretty much have to keep things moving, though. Thanks. The next item is agenda item number 2, the removal of the requirement that each individual applying to the program for enrollment under post-traumatic stress disorder, or PTSD, submit medical records that confirm the diagnosis based upon the evaluation of a psychiatrist, a psychiatric nurse practitioner, or a prescribing psychologist. So those of you who don't know, New Mexico is one of the very few states in the United States in which psychiatric medications can actually be prescribed by a prescribing clinical psychologist. I don't know how many there actually are who are doing that in the state at the moment. Not very many is my impression.
Apparently over 100 have graduated from the program, but the exam to become board certified, or I don't know if it's a license established by the State Board of Psychologists, is very difficult to pass, and so it has about a 1/3 pass rate. So I think we're dealing with fewer than 50 actual prescribing psychologists.
So the reason that I brought this up is because during that period of time when I was the medical director of the medical cannabis program, when I actually used to work for the Department of Health, I found that people applying under the diagnosis of PTSD sometimes had great difficulty providing those materials of diagnosis by a psychiatrist or a psychiatric nurse practitioner. And part of that came about because, not surprisingly, a fairly high proportion of people applying under the condition PTSD were combat veterans who received their care at the VA, and the VA has sort of done this blanket, although I hear that it's kind of observed in the breach in some locations, but that the VA has generally said that they don't want their clinicians participating in this process. People should be able to get around that by simply insisting upon their medical records, which you can do under HIPAA. But that having been said, I think that it can still be difficult for people who have PTSD to lay their hands on a diagnosis by a psychiatrist or clinical nurse psychiatrist. And so I brought it up. I may be wrong, but I don't think it's as pressing of an issue as the thing around requiring the second certification for severe chronic pain, because you're not actually requiring a psychiatrist to sign off on the certification. You're simply asking for a diagnosis confirmed by a psychiatrist, which is different because the certifying clinician can still be your family doc. But I'm just interested in hearing what other members of the Medical Advisory Board feel about this, whether they think there's a problem, whether they think there's not a problem, and if there's a problem, whether we should be addressing it. Yeah, we got it. Like I said, we got it. So. Okay.
And reviewing the Secretary's decision again from the July 26, 2013 decision, she cited the lack of studies in the established medical literature that address the potential for negative reactions by persons diagnosed as having PTSD, and said in consideration of this, it would be irresponsible for the Department of Health to remove this specialist requirement from the PTSD enrollment criteria. It's been my great pleasure and to my professional satisfaction in clinical work to see a large number of people with PTSD seeking the certification under those criteria. And as I noted in my earlier remarks, my initial impression, or over the last 5 years, so my impression over that period of time has been that the use of cannabis can lead to reduced impairment or improved overall level of functioning in people. and in the interval between the Secretary's decision and this hearing today, another New Mexico psychiatrist has published an article about his impressions and his research into the effects of medical cannabis on people who suffer from PTSD, noting a 60% reduction in the rating scale that he used in his practice. So now we do have some scientific research, published research, that would suggest that it is indeed helpful. That's Dr. George Greer, who I believe is now retired from practice. The only downside I could see from removing the requirement or expanding the requirement beyond mental health practitioners with prescriptive privileges is then that there is the potential for reduced referral into other forms of treatment for post-traumatic stress disorder. And there are some promising treatments that involve psychotherapy, or EMDR, which stands for eye movement desensitization and reprogramming, so that were it to be expanded, there is the potential that other clinicians who were not aware of alternate treatments besides standard prescription medications would not be making those recommendations.
I could just follow up on that last concern. A question for you and also a question for Laura is making the diagnosis of PTSD, because this isn't something that I do. Is that a challenging diagnosis to make? And then the other question is should patients with PTSD, all patients in a family practice setting, be referred to someone with mental health capacities, or is a family practitioner adequate to help that patient and treat him?
It is a good question, Dr. Lopez. I'm glad to hear that. I am the family medicine representative on the medical advisory board. I actually practice addiction medicine and currently work with a significant of patients. Pretty much all of them have a solid diagnosis of PTSD for one reason or another. And I will say for myself, given my line of work and the focus of addiction medicine that I currently have, I feel completely comfortable making the diagnosis of PTSD. I also happen to work in an outpatient setting where I work closely with trained therapists who can provide counseling support. I also am fortunate to have pretty solid connections in terms of referrals to psychiatrists such as Dr. Johnson here in the Santa Fe community. But that's Santa Fe. That's not the rest of New Mexico. And as you all know, for the last 2 years, as a public health person, I am really big into improving access to appropriate health care for New Mexicans. That's why I'm on this board. And I feel as though Santa Fe is one part of New Mexico. Most other parts of New Mexico don't have as many psychiatrists who are as interested in working with medical cannabis as here in Santa Fe, quite frankly. I mean, we do see a lot of PTSD medical certifications. I'm really glad to see that. But I do know that there's plenty of other parts of New Mexico where there are no prescribing psychologists or psychiatric nurse practitioners or psychiatrists who would be able to make the medical certification for a PTSD diagnosis for those patients, in my opinion, deserving of medical cannabis to be able to access that. So I really feel strongly that family medicine and other primary care practitioners, internal medicine, for example, are perfectly capable of making a PTSD diagnosis and to be able to provide that written certification that that patient does, in fact, to attest that they have that PTSD diagnosis in order for them to be able to access medical cannabis appropriately. It does help.
There are published, the American Psychiatric Association came out in 2013 with DSM-5, which is the Diagnostic and Statistical Manual that has 7 diagnostic criteria for the diagnosis of PTSD. So any non-psychiatric clinician can access that, and I am diligent in documenting in my certification paperwork that the person before me does meet those 7 criteria, and I believe that continuing to have that level of evidence, were other clinicians to use that same level of documentation, then it would be safe to proceed with the opening of the criteria to all prescribers. I do believe that just saying, yes, this person has PTSD is perhaps insufficient, and there might perhaps be a documentation requirement that would reassure the department that the person being certified is not, quote-unquote, scamming the system.
Thank you very much for that. Sometimes I feel like I may be the Russian judge over here. I don't know. I'm certainly not against using medical cannabis for any condition that the literature supports or some evidence supports, but I don't think that, I think that you may be an exception, Dr. Brown, in that most family medicine physicians don't have a DSM-5 anywhere in the zip code close to them. And so I would certainly second that remark that Dr. Johnson made about at the very minimum requiring some level of evidence regarding those diagnostic criteria.
I think Steve is the best historian here in terms of some of the issues that have come up around PTSD. I think there has been concern on the part of the program that basically if you loosen the restrictions around a PTSD medical qualifying condition certification, that would kind of open the floodgates of applications to the program, and that there would be concern that there would not be capacity for the program to be able to process this flood of new applications for PTSD. And I think it's important to keep in mind that with the new regulation changes, that there is the potential for increased staffing capacity in the program to be able to accommodate any increase in application that we anticipate. I mean, the numbers have continued to increase, as we've all seen, but I do believe there's also the current capacity to increase staff capacity to handle any increased applications. Just a little logistic background there that's important.
Any further discussion? Do I have a motion?
I guess I still need clarification what we're voting on. And that is, no, I understand, but for PTSD, current medical records or clinical notes from a psychiatrist or other clinician is what you're wanting to remove, the notes, but you still, the requirement is still that one of these specialists fill out the paperwork.
Not exactly.
I'm missing something. It's
Yeah.
the notes that you're you're wanting to remove the requirement for the medical records to be
No.
submitted?
No. What I am proposing is that so what is currently required is that a psychiatrist or other psychiatric mental health practitioner, that the records from one of those individuals be submitted along with the application in order to confirm the diagnosis of PTSD. So unlike the situation with severe chronic pain, there's not a requirement that that mental health specialist actually sign off on a document that is specific to the application to the medical cannabis program. So for example, if you are being seen at the VA, if you're a VA patient, you could, under HIPAA, request your medical records that attest to the fact that you've been diagnosed with PTSD, and without your psychiatrist even knowing that you're applying to the program, you could take your records from your psychiatrist, take them to the primary clinician who is certifying you. The certifying clinician could then include those records with the application that you make to the medical cannabis program. So what I am proposing is that pretty much, I think that Laura did a good job of explaining it, is that there are, again, we're sort of providing a bias against people who live in healthcare resource poor areas. That there are, the reality of New Mexico is that if you live in a healthcare provider resource poor area, that you may be dependent upon a primary care clinician for making that diagnosis for you. And so the question is whether or not we should consider, well, there are two questions. The question is whether or not we should consider that diagnosis of PTSD using the criteria of DSM-5 to be satisfactory to the purposes of the program, and again, whether or not it is legal according to whether or not that requirement is legal according to the statute. The statute basically does not speak to that, and so I am suggesting that it's possibly an overreach of the rulemaking authority of the department.
I think it's also, in addition to the previous comments I made, in terms of access, many patients of limited means who have PTSD may not be able to access private medical practices, psychiatric practices, even if one could argue that the care they would be receiving there might be more tailored to their appropriate treatment for their PTSD. Again, most of New Mexico is a health professional shortage area. The federal HPSA designation applies to the whole state, almost all of it. And so it is really a question of access for me. And in addition, quite frankly, not only is it an access issue, but it's also a relationship issue. Many patients who have significant trauma histories, who have a diagnosis of PTSD that can be made with DSM-5 criteria, may or may not feel comfortable disclosing that information to someone that they're just meeting, perhaps for purposes of getting their medical cannabis certification. They may be more comfortable talking to the clinician that they've been working with for the last 20 years, right? That person knows them better than the specialist referral that they may have to get at this point. So I think that should be pointed out as well. I think it's really important.
You want to make the motion?
Sure. I'd like to move that we remove the requirement that each individual applying to the program for enrollment under the post-traumatic stress disorder diagnosis submit medical records that confirm the diagnosis based on the evaluation of a psychiatrist, psychiatric nurse practitioner, or a prescribing psychologist.
You want to add anything about the DSM-5?
I would like to amend the motion to require documentation of the DSM-5, that they meet the DSM-5 criteria, and that the certifying clinician is willing to sign off on those.
Any objections to that amendment?
I would second the amendment, but not the first.
Okay. So the amendment has been accepted by consent. We're back on the motion, so we still need a second on the motion.
Did you second it by making the amendment?
second the original motion.
Any further discussion?
Do I talk about Dr. Simpson's opinion in this matter before the vote or subsequent to the
Or you
vote?
do it afterwards, because he wasn't here for the discussion. All in favor indicate by raising your right hand. All opposed?
Dr. Simpson did vote no.
Okay, all right. Okay, so the next couple of things are the things that we're going to need some, yeah, go ahead.
Sorry, just a bit of clarification then. So the motion was passed, including Dr. Johnson's amendment, right?
Correct.
Okay, and so we need to make note of that amendment. I don't know whoever's
Yeah.
keeping track of that. Okay, great,
I
thanks.
got it right here.
Great.
The next things are things that we will need some help from Mr. Woodward on. It came to my attention, I'm not sure when, but it came to my attention that on the current patient application, there is a release that patients are not necessarily required to sign, although there is an indication that it is highly desirable that they should. A release of medical information. So I have questions about basically what it is saying is that the department is in a position to obtain medical records from a person's clinician that are relevant to their application for the medical cannabis program. Are you familiar with that release?
I'm not super familiar with the application form that you're describing, but I think I know what you're referring to.
Okay. Yeah.
Can I comment on this for practicality?
Yeah.
So I fill these forms out regularly, and oftentimes if I don't, I will say see attached progress note from today rather than filling out the sheet for progress note. And and also in the application form it says, do you keep, if you do not fill out this, is it in your medical records in your office? There's no way I can release any records from my office unless the patient signs a release allowing them to do so.
Right. That's going to be part of the discussion. So it's a question. So I do not pretend to understand all the intricacies of HIPAA. All right. So, but it seems to me that the covered entity in this case would be the clinician who is providing the records to the Department of Health, correct? The Department of Health would, so for those of you, a covered entity is an entity like a medical care provider, an insurance company, yeah, under certain circumstances, where the exchange of medical information is regulated by the Health Information Portability and Accountability Act, or HIPAA, fondly known as HIPAA. And so it would seem to me that the covered entity would be the certifying clinician, and yet the release of information suggests that by a patient signing this, the patient is giving the permission for the release of their medical records. However, it would seem that rather the person who has to do that is the clinician. So I'm trying to think in terms of both the patient's perception of this as well as the clinician's perception of it. Does the clinician who gets this release of information form from the Department of Health, is it possible that they may misinterpret this as suggesting that this is all they need in order to release the person's medical information, and that they don't understand that in fact there would need to be a release of information that originates from the clinician who's releasing the records? And then there's also the statement that I would like clarification on. Where is it? Oh, okay. It says, additionally, I understand that the revocation will not apply to information that has already been released, The information disclosed pursuant to the authorization is subject to potential redisclosure by the recipient, meaning the Department of Health, I presume, and will not be protected by the HIPAA privacy rule. So I don't get that. Could you help me with that?
I'm not really familiar with this form. So I guess I would defer to Mr. Groggle as far as how the program is actually using these forms.
Can you comment upon whether or not the department can have somebody sign something that would say that the things that are released to you are eligible for redisclosure and not pursuant to HIPAA rules?
I'm reluctant to take a position on that. I see the point that you're raising it, and I'm not aware that the program is redisclosing these things to anyone other than obtaining records from the provider or following up with the provider for additional information. So I'm not sure why that would be in there.
But you're saying you're having people sign a form that says that they understand that it's possible that redisclosure will happen and that it won't be protected by HIPAA rules.
As I say, I'm not familiar with that form.
Steve, I personally think this is kind of beyond the purview of the Medical Advisory Committee. I think this is sort of practicality for the department and how they proceed with business. I mean, this is something that every patient in our office signs a release of information if we want to get records from somebody or if we want to release records. It's a standard thing. And I think we're kind of getting into the tiny nuances of this thing that is probably beyond our expertise, at least mine.
Well, the recommendation is just that the department review this, and I think it would be a good idea for Mr. Woodward to review the form. So that's going to be our recommendation.
We have removal
as
as
a
a review.
As it currently,
Okay, I'll
okay,
change it to say review.
okay, right. And when I have patients sign this in my office, it doesn't require any action on my part. It's just part of the application that I say that the patient needs to fill this out as it is part of the application, but it doesn't require physician input.
But I guess I'd like to see if there's a way that we need to be considering the original Lynn and Aaron Compassionate Use Act language around whether this is appropriate or not. I agree with what you're saying, Tim. That does seem like it might be beyond the purview of the Medical Advisory Board, but I have some concerns about that. Are there any thoughts or opinions from us as board members about whether there's anything in the original law around this issue?
You can't release any records in your office unless somebody signs a release of information. That's just period.
Mm-hmm.
So I don't know. It has anything to do with the clinical. I think we're just trying to abide by federal HIPAA law.
Right, but I mean, I think the issue, as I understand it, is we're talking about redisclosure of issue beyond that, which could certainly concern some medical cannabis, patient applicants, right?
So regarding that, I think rather than, I don't even know if we need a motion for this, but I think Steve has asked the department to review this, and I'm sure they will. He's brought it to their attention. I think that's a great job.
There's also, for certain things, the Department of Health is not considered to be a covered entity with regard to HIPAA, particularly for the release of information that has to do with public health stuff, public health data. The department is not considered a covered entity, but I would argue that in this instance, because you are sort of acting in a clinical capacity, that it could be argued that you are a covered entity. And therefore, having somebody sign a release that says that redisclosure could occur without regard to HIPAA privacy rules is an interesting statement. Okay, so do we have a motion I modified the recommendation to review the requirement for signed consent.
Is that a motion, or do you want a second?
I'd prefer that somebody else move in second.
I move that we ask the Department of Medical Cannabis Program to review the requirement from an applicant of assigned consent for release of medical information related to the patient's debilitating medical condition, the form that has been referenced here.
Second what she said.
Okay. All in favor, please indicate by raising your right hand. Any opposed? Okay, thank you. And then I have one more that I hope will not take very long at all, which is number 5, removal of the statement under disciplinary actions and appeal process, which is 7.34.3.16A9. Removal of the statement that disciplinary action may be imposed, quote, for primary caregivers for any determination by primary caregiver's licensing body that the primary caregiver has engaged in unprofessional or dishonorable conduct. Primary caregiver is a very specific thing defined both under the Linen-Aaron Compassionate Use Act as well as under the regulations. It's not a doctor. It is an individual who looks after the welfare of an individual who is in the program when that person can't look after their own affairs for whatever reason. I think what happened was that the disciplinary action thing that's defined here got conflated somehow with the certifying clinician. So I want the department's feelings about that.
Can you hear me? I think you're right. I think it was a copy and paste problem where they must have borrowed text from a section about certifying practitioners. But you're correct that there's no point in having a reference to a licensing body for a primary caregiver.
Okay, so everybody understand the motion or the proposal, and that the department agrees? Okay, so we just all agree? Okay. I think it's a technical issue. All right, so at this point, Dr. Oh, yeah, oh, sorry. This is something that I think we can work out with program and doesn't require a lot of discussion. Actually, what we would like to do is make sure that, the whole idea behind a public hearing is to get public input. And so we would like to make it clear when our hearings are, how much time in advance you need in order to submit a petition for the addition of new conditions, how much time people who want to comment formally on those petitions have to submit it, and then the process by which those individuals can both present that expert testimony and give oral testimony at the time of a public hearing, which didn't happen today, but it happens. So the regulations require that the department 30 days in advance of a public hearing must publish in a newspaper, which is almost always the Albuquerque Journal, it appears, what petitions are going to be heard, and the process by which an individual who wants to submit written testimony and give oral testimony can do that. And generally they have to do that 2 weeks before the hearing. So what I would really like to make clear with program is that we should really decide upon the dates of the public hearing sufficiently in advance so that we can announce it on your website and then tell people how they can submit petitions so that they have at least a month to prepare their petitions. They'll know when the deadline is for the receipt of the petition, and then, which will be 35 days in advance because the department has to prepare a purchase order and has to prepare the announcement itself. The announcement gets published in the Albuquerque Journal 30 days in advance. It will say that anybody who wants to provide testimony needs to do that 2 weeks in advance so that we can read your testimony. And so I just ask that I understand that the department has been abiding by the requirement for the publication 30 days in advance. What I would ask is that the department both help us in making sure that our meetings are scheduled at least 2 months in advance so that we can put it on the website so that people know what the deadline is for the petition receipt ahead of time, so that that can then be published in the Albuquerque Journal, et cetera. So, but I don't think we actually need a motion. I think we've already discussed this, and I think.
Would it be possible for us even to be able to propose a next meeting date at this meeting? So then there would be, I mean, typically, I mean, historically this group has met in April and October, in this case May, and then 6 months later would be November. I don't know if that's a reliable sort of expectation or schedule to be looking at.
Do y'all feel like you might be able to do that?
Basically,
propose dates in November, for example.
Commit to a date at this meeting, so then people who are here already have that knowledge
Right.
of what's coming up.
I'm game.
Does the department have any concerns about that, Mr. Rogel, that you can see?
Not that I'm aware of.
And does the calendar year, I mean, if we have a meeting, is it better to do it in October so that then you can receive the report within the same, and make a decision within the same calendar year? Does that make any difference at all that you're aware of?
We'll do our best to accommodate the Medical Cannabis Advisory Board.
And one other thing that I would sort of like to bring up, and I don't think we need a motion on this. I'm going to put it in the report, but I don't think we need a motion. I think we just need to have an understanding. So you're okay with putting stuff on the website 2 months in advance so that people have an opportunity to prepare petitions and know when the deadline is for the receipt of petitions? You're good with that?
Sure.
Okay. The one other point that I would like to make, and we've made this point before, but I think this is a time to make it again, which is that it's really helpful if the Secretary of Health would rule on the recommendations of the Medical Advisory Board in a timely manner, because it has not been uncommon for the decision of the Secretary of Health to be issued after the deadline for petitions for the next Medical Advisory Board hearing, which makes it impossible for someone who wants to apply again, and there's always a possibility that there's new information that would cause a person to want to have the petition heard again, and therefore that person cannot reapply for a year. So given that we issue our report within 2 weeks of the public hearing, it would seem as though the Secretary hopefully might be in a position to offer a ruling on it within 5 months. Or within 4 months. 4 months.
So how about Friday, October 30th? And he likes Fridays because he goes from home.
Can we wear costumes?
Yeah.
Absolutely.
All right.
Okay, so.
So I'm hearing, so we're
That's 6 months from today.
right, we're proposing Friday, October 30th. I don't know how that sounds to the program for the next Medical Advisory Board public hearing.
More or less.
Have no objection at this time.
Okay. On my calendar. Now it's Dr. Johnson's turn. Dr. Johnson has put in a request to consider the expansion of the qualifying condition hospice care to include palliative care, and I'll let him explain the difference.
It's clear to me that under the very title of the Lynn and Aaron Compassionate Use Act, that compassion is a primary standard upon which we measure our care in this act. And what the term palliative care does is expand hospice, which is the treatment of fatal illnesses, where the expectation of life expectancy is typically under 6 months, I think, in terms of hospice care. it expands that concept of compassionate care, or providing patients with relief from the symptoms, pain, physical stress, and mental stress of a serious illness to an incurable illness. So it's not just a potentially, or an illness where a person's demise is expected within a short period of time, but to expand it to chronic conditions for which there is no known cure, and for which there is substantial debility and other symptoms, pain predominantly. So it's certainly seems like a valid expansion of that term and of the sort of intentions of the Act to include palliative care. And Dr. Jennison brought us two articles that were somewhat relevant, and one entitled Cannabis in Palliative Medicine, Improving Care and Reducing Opioid-Related Morbidity, and he provided additional data from the JAMA Internal Medicine article just of this, was it this year or last year? I think 2014, that suggests reductions in opioid mortality. So it seems like it would be an indicated expansion.
A little personal testimony. My mother died 2 years ago after 3 years in palliative care. And the differentiation between hospice and palliative care in a case like that is not an important one, in my opinion. I think she should have been eligible regardless of whether she was in care for 6 months or 3 years.
I agree with that. I also wanted to point out that Dr. Agarwal, who was the author of one of the papers that Steve and Bill have referenced in relation to support for medical cannabis for palliative care, Dr. Agarwal also presented a cannabis therapeutics in hospice and palliative medicine presentation at the Patients Out of Time conference almost a year ago, last May of 2014 in Portland, Oregon. Some of us were there and heard his presentation. It was excellent, and he has several research articles that are cited to support the use of medical cannabis for palliative medicine. I can make those available if people are interested.
As soon as this is over, I'll be rushing off to Houston to see my 92-year-old grandmother, who would not meet the definition of hospice, but would certainly meet the definition of palliative care. And she's in Texas and not eligible for any of this, so I would certainly support her being eligible for that.
Can I make a technical suggestion?
Sure.
So I would just note that admission into hospice care, it's a statutorily approved condition. And so when you make the motion, you may not want to phrase it in terms of modifying that, because we can't really modify the terms of the statute. So if you phrase it in terms of adding palliative care.
Okay, thank you.
Can I then move, or do you want to, Tim?
Sure. I will move that we add palliative care to an indication for medical cannabis.
Second.
Third. All in favor, please indicate by raising your right hand. Okay, that is the end of our part of the agenda, and now is the public comment period, during which the public is welcome to make comments about what we did today, what we didn't do today, or anything about their experience with the medical cannabis program. There's a list?
There is always a list. Thank you, members of the board. According to the people who have signed in, we'll go from the first ones who arrived. As I read it here, the first person that may be interested is Vicki Garland. Okay. Moving down, next is Larry Love. Moving further down, Leslie McCarran.
I just wanted to welcome the new members of the medical board. Thank you guys for doing this service to New Mexico. I am really proud of this medical board, and I do think it honors eVelting very much so. I merely wanted to make a small point that while we have the health shortage now, we will face something even more serious in 2020. So I advise not only the board but the state to really be aware of how important it is to educate these doctors and to keep them on the board and really take care of these folks. So I would also be more than happy if you guys would consider publishing position papers or doing other educational endeavors. I think you guys wield a really big sword if you want to. It can be even bigger. So I'm always here, always willing to help the medical board. So thank you guys so much.
Okay, next, Nat Dean.
I thought the list was longer than when I came in. Tell me, Brent. He's afraid of the podium. I guess he doesn't want to talk. Thank you for your work. I really appreciate it again, repeating what the person before me said. I really welcome the new members. And I fervently hope that the Department of Health will take under consideration the things that you have voted on this day. I just wanted to note that there's a law, proposed law in Congress with support from both sides called the CARES Act, C-A-R-E-R-S, and I didn't bring the act with me, so I don't know the full title. Maybe someone else does. One of the 6 points in that proposed legislation at the federal level is that restrictions would be lifted on veterans to not have fear of reprisal if they utilize medical cannabis, and that they would be able to receive the recommendation from the practitioner within the Veterans Health Administration. So that's good news. There was another piece of legislation that did not pass, unfortunately, that did address that very issue. So on to, as a patient since 2009, I believe, for multiple conditions, I kind of end up applying under various conditions each time because I have all these different conditions. I have a traumatic brain injury, and I have PTSD and unremitting chronic nausea and chronic pain. So it's a plethora of conditions that I deal with, and medical cannabis has helped me greatly, including removing my risk of overdose and removing my addiction to opiates. I feel very vulnerable signing the release form since I feel somewhat that there's not a clear understanding by the Department of Health of the HIPAA privacy rules, and I would like to see that changed. That's my input regarding that. I would like to believe that my physician clearly understands it. I would like to believe that I clearly understand it, and I would like to believe that others that oversee this program clearly understand it. And I took a course in HIPAA certification, and as our esteemed chairperson said, it's hard to understand. So I think it's really important that be clear and that we be safe as patients to have privacy of our medical records. Thank you.
Next, we have Vivian Moore.
Okay, well, in that case. We're back out. Thank you, members of the board. My name is Vivian Moore. I'm with Mother Earth Herbs in Las Cruces. As Dr. Brown stated, there is a general lack of medical professionals throughout the state. In southern New Mexico, that's even more prevalent. Even though we're, supposedly the second largest state in the city in the state, we still don't have the medical professionals who are willing to participate in this program. Multiple times, Dr. Ward's statements of July 26th have been referenced today, in which she justified not following the prior medical advisory board's recommendations. One statement was that the requirements promulgated by the Department of Health are not overly burdensome to the patients. I don't find that to be true. I don't think many but people in this room would agree with that. And like I said earlier, in Doña Ana County, there are very few medical professionals who will sign the forms, primarily due to the additional information now required. It was hard finding physicians, medical personnel who would sign off when it was one page, let alone now with 5 pages. Thus, the patient has to travel up to 4 hours in order to find a clinician willing to certify, or we have to wait for up to 3 months for an appointment with someone who's willing to come down to Las Cruces. Many patients are not healthy enough to travel, but also lack the financial resources to do so. Due to this, the Department of Health should not be erecting roadblocks to prevent or deter patients from participating in this program, and should be cognizant of the cost to the patients. Additionally, the Medical Advisory Board appears to consist of many medical cannabis clinicians. However, there does not appear to be any current medical cannabis patients employed by the Department of Health Medical Cannabis Program. Barring a requirement that the Department of Health Medical Cannabis Program hires a patient, perhaps regular monthly meetings should be held between the department personnel and patients, and seriously consider the patient's concerns on a more regular basis.
Next, we have David Horn.
Hi, I'm David Horn from Albuquerque. I think my first concern has been resolved most adequately, but I'd kind of like a confirmation. It's the issue of China dumping CBD and I believe another product in our state, and yet there is no obligation, or there may have been no obligation, that the dispensaries disclose this information for consumed buyers. The need is because of Chinese flexibility with the truth and falsification, claiming organic or tested, perhaps skewing the results. It's been resolved because we're requiring the testing. I understand recently a batch of CBD contained 10 heavy metals, which brings me some dismay that this issue has been tabled for the future, except hopefully it's going to be sent to wise counsel so that you can be better advised on that.
We have nothing to do with production, by the way. The Medical Advisory Board has nothing to do with production.
I apologize.
Just for your information. You're going to certainly address it in the program.
This is a voluntary request. If making it a requirement is too odious, something that the dispensaries will not be pleased with, but it's a silly thing that I find very viable with Western medicine and the pharmacy. The little bright stickers that are red or orange, international orange, to say warning, don't operate while operating heavy machinery. I know it's so simplistic that we take it for granted, or do not make important decisions while under the influence, or etc. It would be I think, beneficial to some new users and for the rest of the citizens at large. And last but not least, I want to share something personal. I returned on the Monday after 10 days in Ohio taking care of my mother and her sad increasing dementia, and I had to leave behind my medicine because you can't travel outside the state with it, and Lord knows I didn't want to spend any time in Ohio or get stopped by TSA from completing the trip. But what I found, much to my shock and dismay, that I thought the CBD was nice and light and adequate, I have found that it had made a significant difference in my life, not just in being the pain receptor to capture it, to prevent it from my ruptured disc, but also recently learned that at half dosage it had a positive influence on both the mood management, eliminating some of the anxiety and also depression by minor alterations. I just want to make a note to you all, just as a statistic at best, that I have found CBD to be an extreme value in helping with my depression, anxiety, and severe pain. Thank you for.
Next, we have Jessica Halai.
Good morning, everyone. My name is Jessica Halai. I work with the Drug Policy Alliance here in Santa Fe. We're a national organization that advocates for health policy grounded in science, compassion, health, and human rights. I wanted to thank the department and the board members for your service, and the department for getting new members to this board. It's great to see so many of you sitting up there today. There's only been like 4 at the past couple meetings, barely a quorum, so very exciting. Thank you. And I would just like to say that the Drug Policy Alliance concurs with all of the recommendations that have been voted on today by the board, including the addition of palliative care. I would also like to further assert regarding PTSD diagnoses received from the Veterans Administration that vets may experience, while they may have HIPAA rights to their medical records, they may be afraid to ask for them, and they may experience difficulty getting, really anything done with the VA. We know that Farmington especially is having a lot of trouble and is in the national news. And that there's other administrative and time delays that could be included in making their time frame to get their particular diagnosis recommendation in hand to take it to a certifying practitioner. I would also like to echo the points raised by the board and the audience that that the most appropriate healthcare providers are often not geographically or financially accessible to many New Mexicans, and that compassion is the basis of the program. Finally, regarding hospice, I'd like to suggest that by definition, hospice patients all need caregivers. And although there is an expedited turnaround for hospice patients to have their approval done for the program, there isn't such a combination that their caregiver is also has an expedited approval process. So they can be approved within 5 days, but their caregiver may take 30 days or longer. I know it's supposed to be 30 days. I know once in a while there's issues. So I just wanted to bring that to the board's attention, and I'm not exactly sure how it would be addressed in statute, since the condition is a statutorily approved condition, but perhaps that change could be made within regulation and wouldn't have to bother our legislators with it. Thank you.
Next, we have Sean Gentry.
Good afternoon, Board. I would like to thank the new Bibbers for coming and joining us. This is also my first time here with a lot of you. I'm a member of the Patients Alliance. I was just made a board member as well. Okay, yeah. No, I just shake. Okay, so anyway, I had a prepared statement. Of course, I had to have issues this morning. Always seems to happen that way, and I left them at home, so I'm going to have to wing it this time. Anyway, so the three main points that I would like to address today. First and foremost is the addition of a ailment, but also more of along the lines of conglomeration of multiple ailments. Because one of the ailments that seems to have been completely just completely not seen is spinal stenosis. We literally have not heard much on spinal stenosis, and painful peripheral neuropathy is a symptom of spinal stenosis, as well as intractable spasticity. That's another from spinal stenosis. And I'm not just stipulating cervical, lumbar, or thoracic. I'm saying any of them, because the just pressure on the spine is almost a spinal cord injury in and of itself. So it's one of those things that I just wanted to make it on the record today. I will, of course, be submitting a proposal for this, of course, in due time. I didn't quite know the process behind this.
Can I speak to that a little bit?
Please.
First?
Please.
Okay, so I don't think that we can necessarily anticipate everything. And we often encourage people who would qualify under any of the existing conditions to do so, rather than to submit a new condition. So, for example, in spinal stenosis, by your description, it sounds like a person with assuming it's you, a person with that condition could qualify either under painful peripheral neuropathy or under spinal cord damage with intractable spasticity. So it wouldn't necessarily be necessary to include spinal stenosis.
I'm with you on that. But one of the points that doesn't get made is, say, with painful peripheral neuropathy, the only thing that I have been told personally that will get me on the program under that diagnosis is a nerve conduction velocity test. And I know you medical professionals have heard of this, but this is one of those archaic tests that literally, they usually only perform it whenever we're in surgery, because it just hurts so unbelievably bad. And a lot of us elect not to do it. I mean, it's just, that's undue punishment on us whenever the diagnosis has already been made. And then the intractable spasticity, I mean, that is just a ailment that happens to people that have horrible bone spurs and congenital defects in their spine that cause them neuropathic pain of levels that are amazing. But the whole point is there's so many stipulations for those little, or I should say, I'm sorry, those secondary causes, whereas there's not much on that main one. That main one almost circumferences it all. So it's one of those things where I could go in with my diagnosis of spinal stenosis, and you guys could then review my records and look over what tests have been performed and whether or not it warrants cannabis. But it doesn't require archaic tests, or it doesn't require 6 months worth of doctor's visits to verify spasticity. Do you know what I'm saying?
Good point.
And it's one of those things where it really does make it just so much easier for patients like me. I have myelomalacia. I don't actually have, spinal stenosis, but it is a result of myelomalacia. Anyway, so that was one point I just wanted to make. I wanted to make it and put it on record. My second point is with the new PPL restrictions. Now, I know you guys don't have much to do with this, but it's one of those things where you will understand my point of view from this. The PPL restrictions are causing us to violate our privacy. They are causing us to disclose our personal medical information to people that are not doctors and have no ability to withhold that information. They're not bound legally by HIPAA requirements to not tell anybody about the fact we use cannabis or our ailments. And I mean, that really broaches on HIPAA violations right there. I mean, it really does. It is a big thing against our privacy. Well, you know what, for that, I've taken up quite a bit of time. I really appreciate you guys. And the third point, I'll say for October.
Those are very good points. Thank you.
All right, I appreciate it, guys.
Dr. Jennison, can I make one comment on that? I would suggest that he would qualify under the chronic pain definition, and he would only need to seek one provider who has intimate knowledge of his mechanism of pain. So I think that most doctors, including myself until recently, did not know of those changes. And so it should be a lot easier for him and other patients like him to qualify.
But as he points out, sometimes people who think they will qualify under other things find that they don't for whatever reason.
Cervical stenosis would particularly be very difficult because 90% of the people in here have some degree of cervical stenosis or lumbar stenosis. It would be very, very problematic.
I'm not sure it's the right time to bring this up, but is there any report from the program as far as the rate of application rejections? I don't think we've talked about that yet, and sometimes I know we've had reports from the program about that, those applicants who are denied cards based on their applications. Numbers.
I don't have anything available to me today, but what I can say is that's a very, very rare occurrence. Typically what happens is, as we've stated in the past, that if applications are incomplete during the evaluation process, we will release a request for additional information. They go into pending. There isn't denials per se. Okay.
Somebody is going to add to your point right there. With denials, it seems that it isn't denials that people get, it's that request for further information. And generally speaking, these individuals that get that take it as a denial. And I'm sure that if we get the statistics on how many are still pending, they're in the very, very high 70% percentile.
Let me see if I can help you with something there.
It's almost the way us patients see it as a way to deny us without actually denying us.
In the most recent report that I spoke about earlier today from April 30, on that report, which will also be found on the website, we're posting this now monthly as we get updates. Applied pending information, which I assume means pending application, 48. Okay, if there's no further questions, we now have it open to, and the first person I would ask for would be Larry Love.
Thank you, Ken. I want to thank the advisory board and the new additions for giving you us service. We need your help, and the program needs your help. And I want to thank the Department of Health Medical Cannabis Program for finally, after 5 years, opening up the process for new applicants for LNPPs. As I said, my name is Larry Love. I'm a patient advocate, and I'm an advocate for the program. The Lynn and Aaron Compassionate Use Act is for New Mexicans. And I'm a little concerned about what I'm hearing is happening to some of the LNPPs. There seems to be some entities coming in from other states and from other countries like Canada. There's a recreational company from Canada called Nutritional High that is somehow getting their foothold in here with one of the LNPPs. I'm very concerned about that and setting a precedent. So I hope that this time around the Department of Health really does a great job and gives us hopefully up to 12 new licensed producers to help New Mexicans who are spending their hard-earned money on this medicine, and it's very, very expensive. It's time that these prices come down. I've spoken with many patients, and their concerns are that their hard-earned money is going to leave this state and go to another country or go to Colorado or another place. So I hope that the Department of Health will really do due diligence and give us some really great new producers. Thank you.
Okay, this is, I'm not sure what the time is, so I can't help there, but this is sort of open mic. So if you'd like to come up and speak, please just rise. And
my name is Sarah Doak. I have allergies and I sound like crap today, so I'm going to make this really brief. I first of all want to thank you guys for being our advocates and staying on top of this thing. I was very disappointed today that Mr. Woodward, is that his name? Is he legal counsel for you guys or for you guys? Both. He was very ill prepared, and I just want to put that on the record that we all saw what was on the agenda. He should have looked at it too and been better prepared. And the other thing that I want to talk about is that, and I brought this up before, people with permanent disabilities who have been designated as permanently disabled by the federal government or the state government or any entity should not have to apply through a doctor every year. I don't know if nobody understands what permanent means, but I think that maybe if we were required to register every year, and maybe every 5 years tell you, yeah, we're still permanently disabled, I would like the board to consider that. And if you need to have it come right from a patient, I will write it up and send it to you for your next meeting in 6 months. Thank you.
Yeah, I would welcome that you do that. However, I think the problem is that it's in statute.
What do you mean in statute?
It's in the Lynn and Aaron Compassionate Use Act. And if it's in the law, then the law has to be changed. And
Oh,
we're
another
not.
legislator thing. Okay, I get it. Thank you.
Sure.
anyone else?
Hi, I'm Kathy Sahu. I'm on the program for PTSD, but I have a question for my daughter that we have been struggling with. She has severe scoliosis. She's 33 now. She has had her back totally rebuilt 4 times. I mean, 100%. She is a rod from the very top of the neck to the tailbone, so she can't move anything. But trying to figure out where to get somebody in her situation to say, yes, she does have chronic pain and this is not going to go away is not easy. And I don't even know what kind of a doctor to take her to for that situation. I mean, I get we have, that they will approve chronic care or chronic pain, but how do you know where to take them to get that approved? I mean, her regular doctor can't do it because the chronic pain, regulations say you have to have a chronic pain doctor. And thank goodness we don't only have to have 1 now rather than 2. I'm glad that change came, but now we still can't figure out who 1 is. We were having a hard enough time figuring 2, but, do you guys have any, can she go to an orthopedic? I don't even know where to take her, and is that even qualified in the program?
The one insight that I can provide is that the rule has changed recently so as to state that it doesn't need to be specifically a board-certified pain specialist, but it can be someone whose specialty is relevant to the pain that the person is having. So I would say that in her case, it could be an orthopedic surgeon, it could be a neurologist, it could be, occupational rehabilitation medicine doctor.
And so what comes from that is the cost, of course, in even getting that done. You're talking to somebody who has this disability, and once she gets that authorization, once she figures out how much she needs to get to see that specialist, when her doctor knows, her doctor can write her a prescription, her family doctor can write her a prescription for codeine or morphine or any of those things that totally screw her up, and then she can't take care of her kids, and she can't work, and she can't drive. But she can at least sort of afford him. But if it can't be him and it has to be a specialist, then she's still screwed. And those kind of situations it's really not fair to those of us that have this, since insurance doesn't cover anything, as you guys know. And so, like, there's no help for somebody in this situation.
I wonder if UNM Project Echo might be a good resource. It's available all over the state. You know, this is basically like a telemedicine opportunity, and they have kind of chronic disease management models that apply, including chronic pain, so that people can access UNM resources throughout the state. And so you might want to check online UNM Project Echo and call them, call the nurse manager down there and maybe explain your situation and see what kind of advice they can provide. I bet they can help you, because they have chronic they have a chronic pain track, so to speak, and people basically can call in weekly. They have kind of like an interdisciplinary team that's based in Albuquerque, but it's projected all over the state, right?
Okay.
So that people can call in with, you know, challenging cases that they need help with, that they want to consult the interdisciplinary UNM team about.
Mhm.
And I think, you know, it goes both ways. So I would basically contact them and see who they might recommend for whatever area of the state you live in.
Okay, thank you.
Anyone else? Oh.
All right, my third recommendation and point I wanted to make was education. We have, you know, that point she just made, I had to come up here. We have no education here, none. Colorado is putting us to shame. They really are. Their medical program, you can get on their website and find out everything you want to know about THCV, CBD, THCA, Delta 9, any of it. I mean, you can find out whatever you want to know about it. They also have a nice resource for looking up doctors that may, you know, prescribe it for them. But, you know, I'm not looking for them to, you know, put up a big list of doctors that the DEA can just use as a nice little template for going and busting folks. But the whole point is we need some form of education put out by the DOH so that it does not violate HIPAA, and it can be provided to these patients. You know, let them know what CBD does. Let them know that if it's their first time, they shouldn't go with that 22% THC strain and then get completely turned off of the medication altogether. You see what I'm saying? Also, with the introduction of the new oils, I mean, there's no information for us. We're having patients come to our Facebook page for legitimate information, and that's really, really sad. It's a fallout on the DOH's part. They're supposed to provide us information and education. We're not getting any. Anyway, thank you guys.
Move to adjourn.
Do I hear a second? Second. All in favor, say aye. Aye. Okay, hang on. I need to read the magic words. Once again, if anyone has not signed in on the attendance sheet at the back of the auditorium, we ask that you do so now. The attendance sheet will be included with the advisory board submission to the secretary. The advisory board would like to thank the witnesses who participated today and those who provided written comments. The audience is reminded that the recommendations of the advisory board will be submitted to the Secretary of the Department of Health for final determination. This doesn't apply today, but applicants will be notified within 10 days after the Secretary makes her determination. But there's no applicants today, so forget that. So thank you for attending. We appreciate participating.
Test.